That's up to you. That's fine.
Yes, Your Honor. So we've reached a disposition with the state in this matter where Ms. Roberts will be pleading to count 1, aggravated burglary, and count 3, false representation of self as an attorney. And we have that the resulting punishment will be count 1 will be 4 years in TDOC at 100% to serve per the statute, suspended. And count 3 at 2 years in TDOC, also suspended, to run concurrently for an effective sentence of 4 years with required in-person probation reporting, monthly zero-tolerance drug screens, monthly restitution payments to the victim for a sum of $5,000 and glass door damages to be determined, which the general and I have agreed to coordinate to submit an agreed order for that indeterminate amount, Your Honor, and that Ms. Roberts must truthfully testify in order for this this plea to be entered. Counts dismissed in settlement are 2, 4, and 5, and she has pretrial credits from August 1st, 2025 through May 13th of 2026. May I tender this to the court, Your Honor?
Judge, the only other condition is contact with the victim or
Ms. Roberts, raise your right hand. Let's place you under oath. Thank you. State your full name for the record.
Amanda Murray Roberts.
Ms. Roberts, you're here today charged in a 5-count indictment, but it's indicated that you're going to enter a plea of guilty to counts 1 and 3. Have you seen or been shown a copy of the charges, talked them over with Mr. Vassengill? You and he discussed the range of punishment you're facing as well as any possible defenses you might have. Well, it's indicated that you want to enter a plea of guilty. Do you understand you can plead not guilty and have a speedy and public trial by jury? You understand if you went to trial, you would have the right to have a lawyer and to have one appointed for you if you could not afford your own. You understand that if you went to trial, you'd be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 juries, and their verdict would have to be unanimous before you could be convicted of anything.
Sir.
You understand that if you went to trial, you and Mr. Vassengill could confront and cross-examine every witness the state called to testify, and you could bring in your own witnesses by the use of a subpoena.
Yes, sir.
You understand you would be presumed to be innocent at trial. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial. You understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by pleading this guilty, you're waiving your right to the trial and to the appeal. All I'm going to do is approve what your lawyers worked out.
Yes, sir.
You understand that that is going to result in a conviction, actually 2 convictions that will be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime.
Sir.
You understand everything I've explained to you?
Sir.
You want to plead guilty according to this agreement and waive your right to a trial.
Yes, sir.
Do you understand if you plead guilty, the court of the state may ask you questions about these offenses, and if you answer the questions under oath on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if I determine that you were lying under oath. Is your decision to plead guilty today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No, sir.
You understand I can't accept your pleas unless I'm satisfied that you are guilty and there are facts to support them.
Sir.
And I will ask you, are you guilty of this aggravated burglary charge? Or are we going to have a statement of facts?
We do have, Your Honor, we have a prepared written statement, and now that she's under oath, I would like her to have the opportunity to again review and execute if this is still a statement you'd like to submit. You swear in affirmance.
I swear.
And Your Honor, in lieu of asking questions, the state is going to rely upon her sworn statement. That you read through all of these.
Well, I'm going to read it into the record. So. This is the sworn statement of Amanda M. Roberts. Comes now the defendant Amanda M. Roberts and would offer the following sworn statement in lieu of an oral proffer in open court. I, Amanda M. Roberts, do solemnly swear that the statements contained herein are the truth, the whole truth, and nothing but the truth, so help me God. My co-defendant Christopher L. King, herein King, and William Hagee, herein Hagee, were both in custody at the Dixon County Jail, hereinafter DCJ. King and I communicated by telephonically through the DCJ telephones and by text through the CHIRP system, also supervised by DCJ. On or about July 1st, 2025, King directed me to break into Hagee's real property located at 416 Wayne Duke Road, Charlotte, Tennessee, 37036, hereinafter Wayne Duke Road. King and I remained in communication telephonically as I broke into the premises located at Wayne Duke Road. On or about July 3rd, 2025, I decided to bring a document titled Standard Lease Agreement to the DCJ, which I did, and Hagee executed the same day. On or about July 1st, 2025, King directed me to bring a document titled Tennessee Durable Financial Power of Attorney to the DCJ, which I did, and Hagee executed the same day. On or about July 30th, 2025, I, at King's direction, impersonated attorney Roger Wainick.
Now comes the evidence supporting the guilty plea. The sworn statement describes a carefully planned scheme. It includes breaking into property and impersonating an attorney. Prosecutors say the entire plan was directed from inside a jail. That's what makes this case so unusual. What part shocked you the most?
Just out of curiosity, she impersonated Roger Wainick. That's a pretty good trick. To Hagee through text messages and advised Hagee to transfer his real property. On or about August 1st, 2025, King directed me to bring a document titled Tennessee Quitclaim Deed to DCJ for Hagee to transfer Wayne Duke Road to me. King and I remained in communication, and I acted at King's direction throughout the incidents described above. And this is indicating that she has signed off on this the 13th day. So those constitute the facts. I'll have that marked as filed in this. Are you satisfied with your attorney services?
Yes, sir.
You feel that Mr. Massengill has done a good job of representing you competently?
Yes,
Mr.
sir.
Massengill, you know of any reasons you should not enter this plea?
I do not, Your Honor.
Anything further from the state? Then Amanda Roberts, in docket number 2025 CR 202, upon your plea of guilty to count one, I find you guilty, sentence you to 4 years Tennessee Department of Corrections that will be suspended and to probation, but if you violate your probation, it will be required to be served at 100% release eligibility. Counts 3, you're sentenced to 2 years in Tennessee Department of Corrections. That will also be suspended to run concurrently for an effective sentence of 4 years on probation. You will be required to go to report in person to probation, monthly zero tolerance drug screens, monthly restitution payments to the victim for $5,000 and a glass door damage to be determined, and you must testify truthfully if necessary, and to have no contact with the victim in the case. Counts 2, 4, and 5 are dismissed as a part of the agreement. Thank you.
Thank
She
you, Your
needs to, probably will need to talk to the probation department. You have another inmate.
Up next is going to be Carol Hughes. This is Ms. Carol Hughes. Her case was previously set for a trial in March.
Sir, can I please speak?
The judge has accepted the guilty plea. The defendant avoids prison today but remains under strict probation. Monthly reporting, restitution, and drug testing are now mandatory. Every condition must be followed without exception. One mistake could activate the full prison sentence. Would you call this justice or a second chance?
Please speak.
It is unlikely we're going to be able to find a trial date before January, so we'll set it for one of the January trial dates. How about the 14th of January? Who is, okay.
General Sylvia.
I couldn't see you back there, General Sylvia. Yes.
Your Honor, may I speak, please?
Wait a second.
Do what?
Not yet. General Sylvie, is that a date available to you? You want to talk to your lawyer before we do anything else? Before you make a statement? Or you want to go ahead and make your statement, whatever it is you want to say.
Yes, sir.
All right, set for trial January 14th. Any other inmates?
Yes, sir.
Anybody else got anything? Are you the real Roger Wennick, or are you an impersonator? What do you have, Mr. Wennick?
Page 34, Aaron James Kosarik. Mr. Kosarik is here and the president of the courtroom. We do need to arraign him, but then we also have a motion to modify bond conditions. Take care of the arraignment first.
All right, so is this, have you already been given a copy of the indictment?
I have, Judge, so we'll waive formal reading and enter a plea of not guilty.
Plea of not guilty is entered. I'll need to see the file. All right. The bond conditions are, it's a $250,000 bond. Bond conditions are to have a GPS monitor bracelet installed before release from jail, have no contact with the victims, no unsupervised contact with any minor children.
Notice how carefully every condition is being read into the record. Plea agreements aren't just about avoiding trial, they're legally binding contracts. If Amanda violates even one major condition of probation, that suspended prison sentence could become very real. Do you think this deal is fair, or should she have faced immediate prison time? Let me know below.
Judge, we filed a motion to allow him to have contact with his minor son that was living with him. His son is here. As well as family members too. The son was not part of any of these allegations or anything like that. And these allegations are, I think, anywhere from 6 to 11 years old.
State's position?
Judge, I don't have any grounds to oppose it. I also don't have any grounds to agree with it. I am aware that this child is subject of some sort of custody case in another county, but I do not know what type of case or anything about that.
Do you want to offer any proof, Mr. Wainick, or are you just making an argument?
Judge, I do have Christian Kosarik here. This is the one that we did not want to be on Zoom. We do have him here if you want to hear from him. We can offer that, but other than that, we're just asking, I think, mentioned everything in the motion.
Well, based on the fact that under the motion, he has sole custody of this child, and this is a 15-year-old boy, without any other evidence to the contrary, it would seem to me that I should modify the bond conditions to allow him to have that contact.
I'll draw an order and have it submitted.
All right. That's the only modification.
Yes, that's all we were asking for. Thank you, Judge. Do not do that until I submit the order.
All right, we are set for trial unless something's happened in the last hour.
We do need dates on Mr. Kosorik's case after the arraignment.
Pardon?
Do need a date on the Kosorik case?
Status date for Mr. Kosarik.
Yes.
You want to make it September the 8th, I suppose? Let's do September the 23rd. Try to spread the cases out a little. September 23rd.
Judge, I'll have an order first thing in the morning.
All right.
Thank you.
we have Jonathan Duff in jail.
It was, his office advised us.
What are we doing with Mr. Duff?
He was not needed.
It's just a reset, Your Honor. Mr. Duff has violations of probation that are set today. My hope for today was to get these reset to the June VOP day. He's got a status on his new charges in June.
Right, well, let's just set it for that June date.
Thank you, Your Honor. June 29.
Now comes the most important part of the hearing, the factual basis for the guilty plea. This isn't just paperwork. The court needs actual evidence showing that the defendant committed the crimes before the judge can accept the plea. And what you're about to hear sounds more like the plot of a crime thriller than a routine courtroom case.
All right, so we're set for trial on the Anthony Thompson case tomorrow morning at 9 o'clock. All right, I've got some issues I've got to deal with the lawyers in that case, so we need to bring the jury in at 9:30 in the morning, and then I'll give me an opportunity to deal with the lawyers. We'll go from there. All right.
Let's take a second to appreciate how bizarre these allegations are. According to the sworn statement, the entire operation was allegedly directed from inside a county jail involving fake legal documents of property transfer and even impersonating an attorney. The judge even cracked a joke, but underneath the laughter are extremely serious felony accusations. And just like that, the plea is officially accepted. Amanda avoids going straight to prison today, but she's walking a very thin line. 4 years remain hanging over her head, and every probation requirement now matters. One serious violation could erase the benefit of this agreement in an instant.
The courtroom has reached its final decision. The plea is accepted, and probation replaces immediate prison. The case shows how serious plea agreements can be. One future violation could erase this opportunity completely.